Okay. Welcome, one and all, to yet another episode of WIC TV. It's a cross ideological space where we come together to talk about issues both political and cultural, from the silly to the serious. And, gang, we've got a great topic for you today. Recently, about last week, I believe, the Supreme Court struck down the notion of universal injunctions, where people would go to a district court, and that district court would issue an injunction stopping the president from giving an executive order or for carrying out that executive order. And the injunction would stop it until it could be decided in court one way or the other. And this was designed, initially at least, to prevent people's rights from being trampled on while things are going through the courts. But in a 6-3 decision, the Supreme Court put a stop to that, except under very specific conditions. And we're going to talk about that today. Was that a wise decision, or is it simply handing the president and the executive branch much more power than they had before? We got a great guest list today to talk about this, and I'm excited to get into it. So we're going to pass the mic first to Mike, of all people, right? And tell people who you are, what you do, why we should care what you say, and give us your opening statement. Let's hear it, and then we'll go around. Hi.
Thanks for having me, Wick. My name is Mike. I am a practicing attorney, so I've been practicing law for about 7 years. Licensed in New York and California. The first couple years were in patent litigation and technology transactions, so a lot of IP focus. I actually currently work in interactive entertainment, so still doing IP work, but a lot of work with video game companies, media, internet companies, so on and so forth. All this is to say, I've had quite a few years of legal practice. I don't profess to be a constitutional law scholar, but I do feel comfortable talking about this case. And so that's what I'm here to do. I'm completely new to the debate space. And so again, please be gentle. And thank you for having me.
Okay, well, what do you think about the case? Are you for it, against it? Give us your opening thoughts.
Oh, right. On the case, substantively, I'm against it. And, I have my points laid out. I think that legally, substantively, the analysis on the Judiciary Act, I disagree with. I agree with Justice Sotomayor's dissent. I also believe that the court choosing this particular case to get rid of nationwide injunctions, from lower courts, is a very partisan decision. And I think it's hypocritical of conservative justices to claim to be nonpartisan, objective, originalists when they've had many opportunities to address this issue during the Biden administration. I also think that it's just a devastating case in general in terms of practical consequences, and so I'm happy to talk about all these points.
Okay, we'll get into it as we go. Thank you for being here. Wonderful to have you. Next up, no stranger to my show, Lactoid. What are your thoughts?
Hey everybody, my name is Lactoid. You can find me at Lactoid TV on Twitch, Twitter, and YouTube. So great to be on a panel with all of you here today on this beautiful day. So my opinion on this is, first of all, a little bit about me. I am an originalist attorney. I have been practicing for 5 years, not the full 7, so maybe I got a little bit less credibility there. But in terms of this actual case, I agree with the majority. Before reading it, I was a little bit, I don't really know how I felt about universal injunctions, but I think that Amy Coney Barrett put forward a very convincing argument that it was not intended to be part of the Judiciary Act.
Okay, we'll get into it when we get there. Thank you for being here, sir. Next up, first time person on my show, and we're happy to have him, Tristan, please.
Hello. I'm no lawyer, but I do have, I think, opinions on topics that are pretty reasonable, pretty logical. When it comes to the SCOTUS ruling, I believe that I'm a big fan of the Constitution. I'm a big fan of how most things were laid out. I'm a big fan of the flexibility that is provided within the Constitution to have different laws enacted and changed when it doesn't serve us anymore. And I think that the SCOTUS ruling is a great change on the structure of how we go about things. And I think that most people who aren't on board with it think it's a partisan thing, and I don't believe that. And I don't think we should be creating laws as a result of that. So I'm arguing in favor of the SCOTUS ruling.
Okay, well, glad to have you, and we'll get into it as we go. Last but certainly not least, Radical Coder. Go ahead.
Yeah, I'm Ryan, Radical Coder. I do a lot of debates and I teach people how to code, and sometimes I argue about politics. And I'm definitely not a lawyer, but I did dig a lot into this specific topic and like the specific ruling, and I think regardless of whether you think it's a good thing or a bad thing, it's definitely a major shakeup. It is a huge precedent shift, and I don't think we should take it lightly at all. I think the consequences are going to be generational, it looks partisan on paper, regardless. Again, regardless of how you feel. Obviously, it was ruled in a very partisan way. And it is undeniably going to give the executive branch more power, which it already has been trying to consolidate. So I think we should be at least very suspicious and cautious as we go into it. I don't know. It makes me nervous, but I could be convinced that it's a sound legal decision, but that I don't think. I don't buy that it's just like a purely neutral constitutional analysis. From where I'm standing, it just looks kind of sussy.
Okay, well, thank you for being here, and we will get into it. And with that, the floor is open for discussion, questions, etc. Again, if you have trouble talking or getting a word in edgewise, if you feel like you're being talked over, please raise your hand or DM me or something, and I'll try to get you some space to have your say. But with that, the floor is yours. Take it away, gang.
Yeah, I can start with a question.
Go ahead, Lactoid first, and then we'll get into it.
This is a question for the pro side, and this is, I think, the hurdle really that you're going to have to get over. If the Judiciary Act of 1789 intended for the Article 3 courts to be able to issue universal injunctions, why was the first real concrete example of a universal injunction not until 1963, almost 200 years later?
Well, I want to take issue with your framing. The Judiciary Act didn't have to be intended specifically to enable universal injunctions. What it did was it enabled courts to grant complete relief in equity, right? And the majority opinion acknowledges that equitable remedies are flexible. So the issue then is, can there be universal injunctions that are complete relief granted in equity under the Judiciary Act, right? So that's like the initial question. It's not whether the Judiciary Act enabled specifically universal injunctions. The question as to why we didn't really see universal injunctions, I mean, I also reject the premise that bills of peace and taxpayer lawsuits are not early analogs, right? Which we can get to in a second. But, even accepting the premise that the first one was in 1968, which I think Sotomayor cites a 1963. Sotomayor cites a 1912 case. But, in any event, there are a lot of procedural reasons why it just wasn't, individuals didn't even have standing to bring lawsuits against the government. So, in the 1800s, right, or in the 19th century, it wasn't even possible to bring a case. And this isn't an equity issue or a Judiciary Act issue. This is a standing issue, right? People just didn't have standing to sue the government. So you can't even get, the preliminary step involved in a universal injunction. And I mean, those are reasons why. And there's also a broad expansion of executive power, right, in the recent years. So historically, there just wasn't really a need. And as I'm sure you're aware, if you go all the way back to the founding, the Bill of Rights had to be incorporated. So historically, you just didn't have this problem. But equity allows courts to address problems that law otherwise is insufficient to address. And universal injunctions is one of those ways.
Okay, I'm going to address a couple things real quick. You stated that, you couldn't sue the government. It's true that they had sovereign immunity from any kind of civil lawsuits, but that was waived in the 70s, like the mid 70s. And you see universal injunctions really begin in 1963. That was when at least all parties can agree, like that is like really the beginning of the universal injunction. There are some arguments that maybe there was a few beforehand, but really 1963 is when you first see it, before the government waived their civil immunity. And you also see the government involved as a defendant in prior cases. So, for example, the slaughterhouse cases. And during the Lochner era before FDR brought in his fascist court of goons in order to establish terrible, terrible case law. Oftentimes there'd be, as the decision pointed out, thousands upon thousands of individual injunctions, like regarding individual defendants that were plaintiffs that were parties to the case. And so, if the Lochner court believed that they could have just stopped the government entirely, it seems odd to me that they didn't do it entirely, but instead they did it specifically for each individual named party on the case. And this was the trend going back, and number of cases demonstrate this, going back to the founding. Really, you start to see universal injunctions as a relatively recent phenomenon. It's just, I very much buy the majority argument when they're saying, look, you could, when we're looking at what kind of powers Article 3 courts have, you have to, yes, they have the ability to issue complete relief, but that doesn't mean they get to do anything. What does complete relief mean? Does it mean universal relief? Not necessarily. How they've always seen it was complete relief to the named parties. And that's how the courts operated up until 1963, which it just seems like very weird that during plenty of litigation throughout the entire almost 175 years of American history, everyone was just like, yeah, we can't do that. Of course we can't do that. That's not how it's
you'd agree that over the past couple decades, the executive power has been expanded significantly, right? Under both administrations, like Democrat and Republican administrations.
Not
like aggressive expansion of executive. No, you don't think there's been an expansion of executive power?
Chevron being overturned was one of the, I think, biggest retractions.
No, past couple decades, right? From the 60s up until, let's say the end of the Biden administration. Like, you don't think Biden or Obama or Clinton expanded executive power?
In certain ways,
Bush,
I agree that executive
Trump,
powers. In certain ways, I can agree that like executive power has sort of been expanded, but there's other ways that it hasn't. I think that executive power really was at a very peak high in the 40s during FDR, during World War II. And then it sort of fell off, and then it sort of ramped up again, I think, in the 60s and 70s. But there is kind of an ebb and flow, I think, of executive power. But again, even during these like large increases of executive power and pretty crazy Supreme Court cases in the 40s and the 50s, even they didn't think to like apply injunctions universally. It was always
because it just wasn't necessary. Because it wasn't necessary to afford complete relief to the parties.
So are you saying that
let's get some more people in here. Go ahead, Tristan, and we'll get Radical Coder. I just want to make sure everyone gets a chance, right?
It sounds like you're okay with expansions when it's necessary, because you just said that it wasn't necessary for them to do it, then it became necessary for them to do it. And in that necessity, they were able to use a power that they weren't using before. Isn't that considered an expansion?
Expansion of, I'm saying that, executive power has been expanded. Like that's what I've been saying.
So one, I agree with you, right? But I don't agree that's inherently good or inherently bad, right? You can expand.
I'm not saying it's good or bad. I'm saying that is why we see more universal injunctions, right? Like why we see courts using this tool, this equitable tool, and equity is flexible. It's not fixed in stone, right? It's not like whatever equitable relief was granted, in 1780, whatever the Judiciary Act was, that's it, right? So. And I think Lactoid would agree with this. Equity is flexible, right? Because in the past, right, the English Court of Chancery couldn't enjoin the English Court of Chancery could not enjoin the Crown at all, right? So, like, the majority makes the argument that, the English Court of Chancery would never recognize universal injunctions. They wouldn't recognize injunctions, period, right? Because, like, the old English courts couldn't tell the king, you can't do X, Y, and Z.
I just want to ask, and this is an important point because this is from the majority opinion. Why did the Lochner era court issue thousands upon thousands of injunctions specifically to each individual named moving party, as opposed to just saying the government can't do this? Because they were comfortable saying the government can't do this for Sam, Joe, and Bob, and Tom, and blah blah blah, going on thousands upon thousands upon thousands. They felt comfortable doing
so
that.
The vast majority of Lochner era cases were economics cases, right? They were like businesses and business practices. In those instances, it's almost impossible to fashion to create a nationwide injunction that applies to everybody, right? You have to do it individually because businesses have different needs, they have different business practices. So you have to, whether you use a universal injunction or not, depends on whether you need it to afford complete relief, right? And so it would have been impossible in many cases to draft any kind of universal injunction that would afford. I mean, it might even harm other litigants.
Just to be clear, your argument is the first time we really ever needed to do a universal injunction was in the 60s, when we went through the whole Lochner era, where they went through individual names and granted injunctions, when we have plenty of Supreme Court cases beforehand in which they very specifically say that only named parties to the case are entitled to relief. We have very specific case law specifying this, but all that doesn't matter because we really didn't need universal injunctions until now.
Well, I just want to specify when I say necessary, I mean, like, there's just no other practical way to do it, right? So if you can litigate 1,000... Okay, go on.
So I want to clarify for the entire debate moving forward, it's not that injunctions have gone away. The process in which they happen has changed. You can still do injunctions under protected class action lawsuits. So I think that a district judge should be allowed to do injunctions, and they still can for their district, but not have it applied to everywhere. I think that's a better way to do it. I understand that class action lawsuits take more time, but it's represented by more people. You have Tristan, a lot more cases under that umbrella.
Yeah, and that's how bills of peace work, by the way.
Yeah, and this is to Lactoid and Tristan, and Tristan specifically at first, because I am curious. Given that this was ruled over in relation, I guess, to the birthright citizenship executive order, and given that while local judges, district judges, things like that can, as you mentioned, make injunctions for their specific district or however. I'm assuming that's correct and that's the case, right? I'm not a lawyer, right? Doesn't this put people in a precarious position where birthright citizenship is effectively ended for any state which votes red, whereas any state which has judges that vote blue are still birthright citizenship? Doesn't this create just kind of like this Byzantine kind of procedural obstacle for people who need to seek relief? Maybe I'm just reading it wrong, though. Correct me.
No. I actually agree with you. It does create an issue. And first, I'm going to say that my thoughts on the matter doesn't mean that I believe it's 100% foolproof. I just believe it's better. An injunction is temporary, right? When an injunction is issued, it's Certainly. While the court case is proceeding. So at some point, a definite ruling will be made that applies. Like, I'm not a lawyer here, but I believe it would apply retroactively. So if you're born in Texas and they didn't oppose the ruling or the injunction, so they allowed birthright citizenship to end, I believe at the end of that court case, if the SCOTUS were to rule banning birthright citizenship is not okay, then I believe retroactively anyone that was born in Texas would still be a citizenship. I believe that the court's power is mostly reactive and not proactive. An injunction is a very powerful tool for them to be the opposite of what they were intended to be. And there's still other processes. So I only mentioned the class action part, but you can still have nationwide injunctions through the appeals court or through the SCOTUS. So appeals, they can still happen.
Okay. Yeah, so I mean, we could talk. I think it does make sense to talk about the specifics of this case now, right? So, I mean, you brought up a whole bunch of things, class actions. You didn't bring it up, but what's relevant is the states as litigants as well, and whether you can grant nationwide injunctions on behalf of states. But I was talking about necessity and practicality, right? So let's talk about let's assume a couple of things. Number one, the executive order is unconstitutional, right? We could fight about that, but I don't think that's the purpose of this debate. Let's just say for now that it is unconstitutional to deny birthright citizenship really to anybody. And blatantly so, right? As unconstitutional as going door to door and taking everyone's guns, right? So if we work under that assumption, how do we get to the end result of birthright the executive order being ruled unconstitutional. Class action, as Alito, let's start with class action, right? It's, first of all, I don't even think courts are going to grant, certainly not Justice Alito is going to grant class certification to basically every American or every person residing in America who's not a citizen, right? That would be covered by the executive order. It's also, they're also unlikely to grant class certification to people who aren't even conceived yet, right? Their parents haven't even kissed. I'm not bringing this abortion in this. I'm talking people who are not even a fertilized egg cell right now, whether they can be members of a class. So even if you get class certification for, all the fetuses right now who are about to be born in America, unlikely, but even if you could, people who are conceived in the future are not going to be covered by that ruling, right? So then they're also going to lose their birthright citizenship.
Before I came here on this panel, I brought this with my wife. She disagrees with me, but she made that point as well. And what I learned is that it will be, if the injunction is upheld, it does get applied retroactively. So I understand what you're saying. So I know you have a list of names that typically go
retroactivity. Retroactivity means if they lose their birthright citizenship and the injunction is upheld, then you have to give it back to them. But we're talking about applying, not retroactively, but applying to people who aren't even, they're not people yet.
I don't think that can happen. I don't think the state can take away. I think if a law were to be passed, that anyone who is born would
not
be
a law,
by it.
an injunction granted to a class, right? So you have to define the class. And if we go with the majority's ruling, the injunction can only apply to the members of that class, right? So anybody who's outside of that class does not benefit from the injunction.
So it comes down to how the class is defined.
Yeah, I don't know.
You're not going to be able to define a class, but you're not. I mean, Alito signaled how he would rule on this, right? But you're not going to be able to define a class.
People can't be born into a class. I mean, I don't know. That's a tough question. I don't think that's been answered yet. But presumably people could be.
Well, based on my cursory legal research, no. But even if they could, right? It's a very, very difficult. It's hard enough to get class certification for people who are already conceived, right?
I see what you're saying.
Just to kind of sorry. Yeah,
Go ahead,
I mean, yeah. It feels like regardless, this is going to put people in a very precarious situation. No, a lot of people in a very complicated. I mean, you could shrug it off, but this is we would agree this is a huge deal, right? And this is going to a bunch of people are going to be in a kind of legal ambiguity. There's going to be legal ambiguity about their citizenship for an indefinite period of time, right?
Well, what do we mean by indefinite? Because the Supreme Court's going to decide on this question.
As in, we don't know how long it will be until it's decided. Right?
We don't.
But that kind of happens regardless.
It's probably going to be October.
Well, that's what indefinite means.
Well, but I think to your point, Radical Coder,
to be clear, not infinite.
Let's say it takes 6 months. Okay, think of all the people who are going to be born in 6 months, right? And maybe there's a patchwork structure between the states. Maybe there's some individual injunctions. All the states have to keep track of who gets a social security number, who doesn't get a social security number. And what if, you give birth in one state that doesn't have the injunction, and then you go to your home state, or you move, right, within that 6 months to a state that does have. And so it's a practical nightmare, right? Even if you don't care, if you're I really do not care about children of undocumented people in America, it's still practically how do you even address the issue, right? You can't. And so in this case specifically, universal injunction is really the only way for assuming if we're operating under the assumption this is a blatantly unconstitutional law, right? So executive order. So the Supreme Court could have easily, in this case, they could have dialed back universal injunctions. They could have said, we have too many. We have to, raise the standard required. You have to have this super heightened standard of constitutionality or unconstitutionality, right? You have to go through all of these other possible alternatives. And then maybe, you can grant a universal injunction, right? If all of these things are met. But they didn't do that in this opinion. They just said no, full stop, right? And specifically for this case too, go on. I don't want to steamroll.
Just to clarify, the SCOTUS can't create laws; they can only interpret them. So that would be Congress would have to do that. And there is actually a bill that passed, I believe, the House that's sitting in the Senate that addresses this issue in a way that I think is better than the previous system and the current system.
So Congress can pass laws, right? That's their prerogative. But the Supreme Court makes rules about, within their Article 3 power, right? So, for example, they establish standing, right? They establish pleading requirements. They establish all of these things that impact whether people can bring lawsuits or not. And they also establish the standards for granting an injunction at all, right? Like, these are the 4 things you have to meet to grant an injunction. These are the 4 things you have to meet to grant a stay. They could easily say, these are the 4 or 5 things you have to meet to grant a universal injunction, right? They could have allowed for that, but they instead just said, no, full stop, lower courts on universal injunctions. And
Not
then
full
they
stop.
they left
I'm
open
sorry.
a sliver,
Yeah.
of class actions, potentially state litigants, right? Potentially state litigants, and also Justice Thomas left open a sliver of complete relief because, and I think the conservative justices did this, right? Because if a Democrat comes into power and does try to take everyone's guns, right, they could leave an opening and say like, oh well, they either grant class to more easily, etc.
Finish your point, and then I
Yeah,
have a question for you guys. So
they could grant class certification more leniently. They could also just define complete relief, like, okay, one person might say, well, as long as you don't take Lactoid's gun, that's giving him complete relief. But then a conservative judge might say, well, actually, the Second Amendment is about fighting tyranny, and Lactoid can't do that by himself. So in order to grant, complete relief, we have to make sure no one's guns are taken away, right? So like, they have left open that possibility, but again, to allow them to do so in a very partisan way by adjusting the sliding scale of what's complete relief, right? What's a class, and what's acceptable third-party standing, right? That's for the states.
So,
Can I?
just a moment. Let me get this out, and then I'll toss it to you, Lactoid, right? Because I want to get this out before I forget it, right? Because the issue was brought up earlier, and I think it's worth discussing since I think it's come up now as to the partisan nature of this. The Biden administration, I believe, asked the court to look at injunctions and things like that, and this court specifically refused. So why, Lactoid, do you feel that this do you not feel that this taints the ruling, given the nature of when it's being done, given the fact that this court refused to hear it under Biden, but suddenly is now granting the Trump administration this power, this excess? Go ahead.
Yeah, well, I wanted to address some things, I guess, to directly answer the question.
Go ahead.
I don't know the circumstances behind what the Biden request was. I'll look into that briefly while we were having this conversation. Oftentimes, what I've noticed is that Supreme Courts will address issues as they come up. Sometimes they'll kick the can down the road. Sometimes they won't. It's a little bit unclear. I don't think this necessarily demonstrates a partisan reason. It could indicate a partisan reason, I suppose. There could be evidence for, but I don't think it necessarily determines it to be. What it could be is that we're seeing this becoming more and more of an issue as time goes on. I mean, the level of the number of universal injunctions against Trump this term have been record-setting. I mean, it's just beyond anything else. And so, what it could indicate, I suppose, to the Supreme Court is this is a problem that we can't keep kicking down the road. We have to address this now because this is just becoming nothing but a bigger and bigger problem. I think that would be like a nonpartisan reason why the Supreme Court would be addressing it now. In terms of the unworkability of the kind of a patchwork citizenship system, I mean, there's arguments, I guess, both for and against the practicality of this. I think that not having universal injunctions has a problem of people getting around standing and forum shopping, right? Finding a specific judge somewhere that they know will rule in favor in order to cause block a nationwide law, even if it may apply really to people who otherwise wouldn't have standing. I think that's a concern. But at the end of the day, I think that's actually an argument in favor of the majority's opinion, which is that class actions have a bunch of restrictions and rules. You even said it's hard to become part of a class during class action. And so if we have these rules for a class action and they exist for a reason, why ever have a class action if you can just get a universal injunction? What's the purpose of even going through the effort of going through the federal procedure to have a class recognized, have people added as a member of that class, et cetera, when you could just simply nix all that, not go through that hassle, and just get a universal injunction? I think that's strong argument for why this doesn't make any sense. It's directly at odds with class actions. But
to answer that question, go on. I'll answer that when you're
again,
done.
the last point here is, ultimately, it doesn't matter. I 100% agree with the majority when they say whether or not this is like inconvenient for you, like it's an inconvenient truth. Sorry, you guys have to work it. You guys have to fix it. It's your job to fix it, Congress, right? You guys have to fix the problem. Our job is to interpret what the law is, not make the law easy for you. That's not the purpose of the courts.
Okay, so I want to address the two things you said. I think the first one was, why do class action if you can have a universal injunction? I mean, these are two things that have existed for decades, right? Assuming it started in 1963, people still, try to certify classes, and they still pursue class actions. They don't just always go for a universal injunction. And there are tons of reasons for this, right? One is maybe you only want the ruling to apply to your class, right? But I want to address the second thing you said. Huh?
What scenario would you just want the law to not apply to your class, but apply to everybody else?
Well, for plainly partisan reasons, right? I mean, that happens all the time, right? If you're a partisan litigant, you're like, well, I only want the law to not restrict, the members of this class of Republicans or Democrats or whatever. That happens frequently. But to answer your second question about inconvenience, right? I am addressing the necessity for the purpose of equity under the Judiciary Act, right? Like, how do you grant equity? I'm not trying to say the Supreme Court has to make the law convenient. I'm saying that the Judiciary Act enables courts to grant complete relief in equity. And because of the unworkability of any other possible remedy in a world where the executive order is unconstitutional, and this is really the only way to do it, right? Therefore, it is permissible under the Judiciary Act. But and just one more point, you said, why not let Congress fix it? I mean, this is an executive order, right? So unless you're saying Congress needs to pass a law.
I'm specifically referring to the Judiciary Act, because what the opinion states is that regardless of what
you mean
issues,
draft a new Judiciary Act. But I'm saying, how do they fix this executive order, right? If we're in a universe where the executive order is plainly unconstitutional, how does Congress fix it, right? I mean, impeach Trump, right? With this, two things.
Really, no, hold on. So if we're talking about injunctions, they can simply pass a new Judiciary Act. If we're talking about the constitutionality of the 14th Amendment as applied to illegal aliens, they could pass an amendment specifically granting it to illegal immigrants if the Supreme Court.
No, it's already there. The 14th Amendment already grants birthright citizenship, right?
I agree. I think it does, and I think the Supreme Court's going to rule that way. And when they do, that will essentially nullify this entire issue of whether or not the injunction will apply or not, because at that point it's against the law.
I do want to respond to that, but you've been trying to say something, Tristan. So why don't you go ahead?
Just so that I can better formulate an argument for you, how are you defining equity in this situation, in this conversation?
So equity is a very technical legal term, right? So don't think about equity in like the sociological or sociology sense.
Not DEI, in other words. Yeah, go ahead.
Yeah, we're not talking about DEI. Equity is basically like allowing the courts the ability to fashion relief that's not traditionally available at law. And relief traditionally available at law is like money damages.
To the parties.
Let me just give you,
parties is how it's been historically interpreted.
Well, bills of peace and have not been to the named parties, right? Traditionally,
yes, they have. They've been to specific, insular classes of people, much like a class action.
No, but they're not named parties. Like bills of peace,
other
have
parties were brought
relief.
into. The other parties in the class, like in the group, have been brought in as a party. Like they're all a single party, but
they're not litigants.
Never applied. No, but they're in the same way class action, or in the same way people in part of a class action are litigants. They are litigants in basically exactly the same way.
But they didn't.
Bills of peace never applied universally. Do you agree that bills of peace never applied?
Let Mike finish his point. I want to hear his answer to your question.
Well, no, I'll answer that question too. Right? Bills of peace. I mean, defined universally, right? They applied to everyone that the ruling applied to, right? So they applied to them wherever they happen to be. And another thing is in bills of peace, right? They didn't have to get class certification the way you do in a class action, right? They were just given the benefit of the ruling. They didn't have to get class certified, right? You didn't have to get certified for a bill of peace. But there's also taxpayer lawsuits where someone could sue, right? You can't do it anymore because of taxpayer standing case law. But historically, you could sue over a tax, right? And if you win, the government doesn't get to collect that tax from anybody.
This was not at the time of the Judiciary Act. This was decades later, and it was regarding state law, not federal law. So it's
Yeah,
like
but it was
entirely
still-
irrelevant
it was-
to this.
But it's a concept that existed at the time, right?
It's a concept.
We're talking about what was
it-
in the minds of the drafters when they
of
made
the drafters, but that was like decades, like 50 plus years following the Judiciary Act, and it was specifically thought up of within certain states, not all states, within certain states to apply within state law. The drafters of the Judiciary Act, there's no evidence that they were considering these kind of taxpayer cases when they were drafting the Judiciary Act. Bills of peace, I agree, were present at the time. But when you look at how bills of peace were applied, there absolutely was a process. Maybe it's not exactly the same kind of certification process that we have currently for class actions, because obviously over time we update kind of the way we do things compared to how the British did things. But there was a process for identifying like who is going to belong to this class of people that we're going to grant relief to under the bills of, under a bill of peace. And it did not apply just like to the law itself. It didn't apply facially to the law. Bills of peace didn't strike down a law. What they did is they identified a group of people, and that took some time to find out who exactly was part of that group, and then granted them specific relief, which is exactly how a class action works.
I mean, I think the difference between a class action and a bill of peace is the class certification process is very, very important. I mean, the opinion talks about it at length, right? If you don't have a class certification process, and the majority opinion acknowledges this, class certification is a more restrictive form of relief than bills of peace. Like, so bills of peace were already more broad relief than class actions were. So there's no reason to say that we're limited to class actions, which is, again, more restrictive than what was historically available.
No, but we made class actions more restrictive through the rules of federal procedure. We identified like specific processes that we want people to go through when it comes to class certification. But we're looking at like which is more analogous, right? The Bill of Peace, which identifies a group of people and gives relief specifically to them, and a class action, which identifies a group of people and gives relief specifically to them, or a universal injunction, which identifies a law and says this can't apply to anybody,
but
not an
class
insular
actions,
group, not a group.
There's
you would agree that bills of peace. You can't find me a single example of a bill of peace applying to the whole country. You can't find
No,
that.
I agree. I agree with that, but I'm saying I don't need to, right? Because there isn't some rule that there only needs to be one analog, right? Like, oh, we have bills of peace, now we can only live as a class action. That's not the analysis. The analysis is what was the intent, right? Around the time they had bills of peace. Now we have class actions, that's fine. No one says the Judiciary Act doesn't allow for class actions. But we're talking about whether universal injunctions, again, we also do have to look at the literal text of the Judiciary Act, right? Granting complete relief. And so take that
Complete,
with
but not universal.
Yes, but what if, so not always, right? But sometimes complete relief is universal. And if complete relief
Just
is
real quick,
universal,
can you give us
why
an
can't we
example of
grant-
that? Hold on, I got to get to super chats in a second. I'll get there in a second. But Mike, can you give us an example of where in order to grant something or someone or a party or a group of parties complete relief, it would have to universally apply?
Yeah, I mean, the common examples are environmental, right? So if let's assume that we're all talking about rules that are unconstitutional on its face, right? So if the executive is like, we're gonna, burn down this entire national park, right? And national parks span multiple states, and so one person sues, right? One person sues like this, you can't do this, right? And let's say this one person has a ranch on the national park, okay? Now, one way to afford relief only to that guy, right? The court can say, oh, well, okay, federal government, you can burn the whole forest except for like his property, right? So like you have to put out the fire on his property, but then you can burn down the whole national forest, right? But that doesn't give him complete relief because now he's on a patch of, he's got trees in the middle of fucking nowhere in a burned down wasteland, right? So in order to give him complete relief, you have to say, no, federal government, you're not allowed to burn down any bit of this forest, right? So like, the most obvious examples are environmental, but again, not a conservative, but you can make the same argument for Second Amendment cases, right? That like, in order for the Second Amendment to have any meaning, you can't just have one guy with a gun, right? Everyone needs to have guns. So
that's more of a stretch. The environmental one, I think, is probably your strongest argument, and I think the majority even goes.
I don't think so.
Like a noise complaint situation. But and then I want just 1 second.
Yeah, get to your point. Then I
Again,
got to
it's-
read
it
the super
seems-
chats and thank people
Sure.
for memberships. Thank you guys for giving me money. Give me
It-
more. And then I want to get the non-lawyers in here just for a little bit.
I just want to emphasize this. It seems odd to me how we're saying, oh, look, a bill of peace does this, which seems to, I think, pretty intuitively almost identical to what a class action does. And you're saying, well, it could also apply to universal injunctions. It seems odd to me then why it seems like the court didn't think so, or at least didn't act as if it did, literally from the time of the Judiciary Act, even through the Lochner era, when they were issuing thousands of injunctions for individual cases, all the way up until the 1960s, when you saw really, I think, just a crazy amount of Supreme Court power just kind of being grabbed away from the other branches. So I don't know. I think that if you're asking me to believe that the people at the time of the drafting of the Judiciary Act, that they saw bills of peace as, oh yes, of course this applies to universal injunctions. We're just never going to do it, even when it makes sense to do it for the next 175 years in a way that like would undermine a whole bunch of different things, a bunch of different rules that we have currently that we're okay with. It just seems very unlikely.
Okay. Let me get to these super chats and keep them coming. I'll keep them reading, and then I want to pass the mic to Radical and then Tristan for a bit and get some more kind of like regardless of the legality here. And let me get this out. Regardless of the legality, do you think this will be good for the country or bad for the country, and why? And maybe we can get there, and maybe we can drag Radical in a little bit more to this conversation. But let me get these super chats. So, $10 from Artemis Fowl to say the 14th Amendment doesn't grant birthright citizenship. It's why Native Americans born in the U.S. had to be given citizenship later on. Even the pre-amendment debates point out due loyalty reasons. And then $2 to correct a typo saying given citizenship. Thank you. And then 5 gifted Wick TV memberships on YouTube from Zetsway. Thank you, Zetsway, for the 5 Wick TV gift memberships. Yeah, gang, keep my lights on. Keep those super chats coming. Keep things going. Let's pass the mic to Mr. Radical Coder. Go ahead.
Yeah, first of all, I agree. Give Wick lots of money, especially when he has me on. Yeah, so we mentioned that Trump, there's records being set for the number of injunctions happening under Trump. And this was true of his first term, as I understand as well. I don't, I think what this could kind of be argued either way. Like, it suggests that there is going to be more scenarios where we're kind of dealing with, like, the edges of like established law, which it does feel like. I mean, from where I'm standing, my non-lawyer perspective, it feels like that Trump and this admin is kind of like intentionally leaning into these like weird corners of law, and I feel like you kind of shrugged this off earlier, but just in the birthright citizenship situation alone, again, this puts a lot of people in a very precarious situation, and I don't think it's going to be just limited to that. I think that what's happening now is that it's more difficult if people, and to the Second Amendment case and everything, like if people are being put in a situation where their rights are being impeded on, they are now in a more difficult position trying to alleviate that, and that seems problematic, and like it seems weird to suggest that the Supreme Court shouldn't need to take like practicality into account. I feel like they do or should. I don't. Maybe there's. I mean, there's got to be. There's again. I don't know what the precedent is for that. I feel like that's a pretty easy thing to acknowledge. But
so for
the
me,
practicality
I do think
comes in as what is complete relief. But yeah, go on, Tristan.
I think this is practical. I think what is happening is practical. So I'm gonna ask you a clarifying question, just I guess for everyone. I think we agree that injunctions should exist, but we disagree on who should have that power. And I would like for you guys to explain to me, why should a district judge who presides over a specific district, who represents different interests than other districts, have the ability to stop that nationwide, right? I can even use your environmental example. If I grow a forest because I want to burn it down, why is that right be taken away from me just because someone on the other half of the nation is doing that? Don't you think there should be a process that can separate those two rather than apply to everyone?
Well, so I'll answer that, not as a lawyer, right? Hard to do, right? But like, let me put it this way. If I sue one of you guys in federal court, and let's say neither of us live in Washington, okay? And I sue you in Washington, I manage to get jurisdiction for whatever reason, right? Maybe you hit my car there or whatever, and I get diversity jurisdiction. That court can issue a ruling that governs you, even though you don't live in Washington, you're not within the district, right? As long as they have the jurisdictional rules met. So that's just how the federal court system works, right? The federal court can grant relief. And by the way, what we draw a distinction between nationwide and universal injunctions because even under the current ruling, this court can grant relief across the nation. It's only limited to the specific litigants, right? So you could get a whole bunch of people in all 50 states, one in each state. They all sue in a single state, Maryland. Maryland can grant relief to all 50 people outside of its district. So there is no limitation, even under the majority opinion on like geographics, right? So I think like you can't really think about things geographically. You have to think about it as power relative to the other branches. And I think that's what the majority opinion is trying to say is that, well, the district courts shouldn't have the power to restrain the executive branch, not geographically, but just period, full stop, right? Because you could imagine a universal injunction that only applies to everyone within the district, right? Universal meaning you don't have a class. But it just so happens that the law, like let's say, Democrats, like, I'm really concerned about Texans. Well, Texas has 4 districts. I'm really concerned about Alabama. So I'm going to take all the guns from everyone in Alabama. Plainly unconstitutional, right? If a single person sues in the District of Alabama and Alabama grants that injunction, that's a universal injunction, not nationwide.
Is that okay?
Universal.
Like one person suing on behalf of something that one person wants to do has an effect on everyone. Is like, how is that something that we're okay with?
I'm addressing your geographic concern, right? In that case, that is a universal injunction that applies only within the District of Alabama. So I guess that's the first point is the geography is not particularly relevant. I mean, would you be okay with the Supreme Court? Like what's the difference then? Because if a district court rules one way and the Supreme Court overrules them, then it gets overturned, right? So your argument that, well, it's all temporary anyway and the Supreme Court's the final word, true. But preliminary injunction is to prevent temporary harm. And part of the analysis...
preliminary injunctions can still be done through a higher court. Through the SCOTUS, before a ruling even comes in, they can still grant preliminary injunctions. It's not like harm can be done permanently within that temporary time, right? That's the whole point of an injunction is to prevent. But that's true for and against injunctions.
That's right.
Right. It just depends on the case.
Yeah. Well, it depends on the party, right? So an injunction could protect one party while hurting the other. So part of the analysis that this court dodges, by the way, is what is the whether there's irreparable harm done to the litigants and the government. Now, I think everyone agrees there's irreparable harm that's going to be done to people whose babies are born and they're not given citizenship, right? That's obvious. The question is the government going to be irreparably harmed, right, by this injunction? And the majority opinion says, I think incorrectly, that anytime you tell the government they can't do something, that's permanent harm, right? That's literally what the majority has said. And by the way, that's going to come back and bite them in the future. But
well, it's a harm to democracy, right? Because these are elected decisions, like elected officials making decisions. That's the argument.
Well, not necessarily. Well, I mean, I don't look at all the Trump voters saying this isn't what I voted for, right? So, like, I think not necessarily, but it.
Well, that's how representative democracy works, right? You vote for a guy who then does things. You might not endorse everything that he does,
but then you can't destroy. So you're saying that basically anytime someone, a court, even the Supreme Court, stops the government from doing something plainly unconstitutional, that the government is irreparably harmed. And so we just don't have to go through that analysis at all.
When you're saying plainly unconstitutional, I mean, then I would say no. But if it's constitutional and they were stopped from doing it for a long period of time, then yes, right? Then they were
so sometimes
harmed. Sometimes they are. And so for me, I mean,
and so it should be a sometimes analysis. It shouldn't be all the time, right? So I'm saying they should go through the steps of the analysis. Like, what is the harm to the government? Because the government can just deport these people in the future, right?
But of course, But again, this is part of the problem with forum shopping. Of course, you're going to find a district judge who always agrees that like the people are more harmed in this case and the government is harmed. And then you're going to find but you're not going to go to the judges that think the government's going to be more harmed because they're going to rule against you. You're going to find the very specific judges that will always rule that your harm outweighs the government harm. And then they're always going to rule that your harm outweighs the government harm. This is part of the problem with universal injunctions, right? You're going to find forum shopping. You're going to find specific people, specific judges to nullify laws, even when other judges wouldn't.
Yeah, but
based on a subjective analysis.
But all these cases, number one, are always going to go up to the Supreme Court anyway, right? And the federal
Right.
judges don't like to be overruled, right? So like you know, when you say forum shopping, you know, and I'm not one to say this, right? I don't think federal judges, at least district court judges, are plainly partisan in a way where I really don't think there's a single federal judge in the country, not even Judge Eileen Cannon, that would rule that this executive order is constitutional, right? I mean, maybe Eileen Cannon.
That's ridiculous. Come on,
but
you're gonna find somebody who would.
I want to jump in here. First,
go ahead,
this
Tristan,
ties in,
and then I want to.
this
I
ties
have a
into,
question, but go ahead. Yeah.
Okay, this ties into your previous questions. I'm glad before we get to your next one, where you brought up under Biden, they didn't talk about. I don't know the specifics of them not appealing.
So they used
Biden
so I'll just give you specifics. They used universal injunctions
Mm-hmm.
several times against several decisions by the Biden administration.
Okay.
And in each case, right, they failed to rule when the cases went up or during these things. They failed to make any ruling or any mention of these injunctions. Really, at least to my understanding, not that I could find, and I'm not a
right.
So I
so
came
Biden-
prepared with
again,
one.
bringing it up now seems to a layman a partisan act when you did not before. Why is that
All right,
wrong?
so I have an example. I have
Please.
an example that happened in 2023.
Please,
So
go ahead.
Biden was
Yeah.
president, and I have it written down. It's the FDA versus Alliance for Hippocratic Medicine, and that is where the Alliance for Hippocratic Medicine specifically incorporated themselves in Texas 2 weeks before they filed a lawsuit in which they banned a specific birth control drug, and then the Texas courts granted them an injunction to where all 50 states could no longer use that drug because of that one injunction, right? So, of course,
Okay.
the SCOTUS eventually ruled that that's not okay on the injunction. So they struck down the injunction, and of course,
Yes, but
the case.
you understand how that's different from this case where they struck down that specific injunction in this case, but they did not rule on injunctions in general as they have in this specific case.
Well, wasn't it the district court that brought that injunction, and then they ruled that the court doesn't have the power to do that injunction? How's that different from what's happening here?
So I think that
I think
to answer your question, that was a specific, and at least as I understand the ruling, this ruling is a general, right? So they're saying you can't do injunctions like this against anything at any time unless it meets these specific criteria, which is, for example, I believe a narrow sliver of complete relief, a narrow sliver of class action, or against individuals, but you can't do universal injunctions at all. Whereas in that specific case, they were saying this particular injunction does not meet the merits, so this particular injunction, we're going to overturn it. Not that you can't do it, it's just we're going to overturn this specific one because we ruled against the case. Why am I wrong?
But if they rule, if the reason is the same, but it's specific versus general, I don't see the I see one is a cosign for another, one is a precedent for another, right? If the specific reason they did away with it is because they don't have the power to do it on that specific one, why can't that be applied in general?
I mean, let's step back a bit. I think the partisan point that Wick is trying to make is that during the Biden administration, there have been multiple nationwide injunctions granted.
How many?
I don't know off the top of my head. I mean, the majority counted it, but
I have it here. No, it's not quite a large number. I've got it right here, and this is why I think, again, as problems get worse and worse, the Supreme Court may find it necessary to take up the issue. George W. Bush had, during his 8 years, somewhere between 6 and 12, Barack Obama 12 and 20, Donald Trump's first term 55 to 64, Joe Biden 14, Donald Trump 14 to 25 in his first 2 to 3 months.
I mean, it sounds like Donald Trump is trying to violate the Constitution.
I know you're saying this, right?
Look,
you're saying,
it's so weird how I have 50 felonies and you only have one. That's crazy, right? Oh, 50, the torture must be against me.
Unfortunately, that is an important thing to bring up. Hold on. Unfortunately, that is an important thing to bring up. Like, you do want to look at political weaponization. You do want to look about here's the president that's getting all these fucking felony counts when other presidents haven't. That is an important.
Why wouldn't it be applied to Bush?
That is an important thing to look into.
Why wouldn't if it were partisan?
No. because Trump is very different than George W. Bush from even just a political perspective. MAGA is just a different animal when it comes to like its populist message compared to the neocons and the neolibs who were basically in lockstep for most of the early 2000s. Like,
hold up. As someone who lived through that era, I promise you that's not the case. But go ahead.
Well, I also lived through that era, and I've seen the Pew Research. Okay, I can link you some studies. But I just want you can say, well, the reason why Donald Trump has like by magnitudes greater amounts of injunctions than other presidents, specifically Joe Biden. Well, it's because of Donald Trump is just like uniquely violates the law constantly. You can make that argument, but like, if we see this amount of universal injunctions, like regardless of whether or not he's violating the law or not, and you're seeing it get more and more and more, it could absolutely give reason for the Supreme Court to take a look at it, especially if Article 3 courts can't do it, which the Supreme Court just ruled. The Supreme Court just ruled that all those injunctions
the Supreme Court
were wrong.
The Supreme Court said, I mean, they didn't answer the Article 3 question, and Justice Kavanaugh seems to take the position that the Supreme Court does.
They said they can't. Hold on. They specifically said
in the majority opinion said they're not going to take up the question on whether Article 3 gives them the power to grant nationwide injunctions.
Hold on. I know that part. They're specifically referring to the Supreme Court with that.
Yes,
okay,
the Supreme Court.
But the Judiciary Act is what grants Congress the ability to assign judges under Article 3. So when I'm talking about Article 3, I'm talking about the judges that are created by the Judiciary Act under Article 3. And all of those judges, those are the ones that were issuing injunctions against Donald Trump. And you can say, well, all those injunctions were because Donald Trump was doing a bunch of shit. Well, it turns out those injunctions shouldn't have been even put forward. Turns out Donald Trump should have been able to do all that shit unless you were to identify specific parties and issue injunctions regarding those specific parties. That's what the Supreme Court said. So yes, this is important when you see a dramatically large amount of injunctions during Donald Trump. That's a perfectly understandable, nonpartisan reason why the Supreme Court would take this up right now.
Nationwide injunctions, where you said they started becoming a problem in the 60s, right? So it's not like nationwide injunctions are cool. Yeah, but the courts didn't create nationwide injunctions as a tool just to mess with Donald Trump, right? You're characterizing it as
right. Hold on real quick. You're right. They didn't create it to fuck with Donald Trump. But what they did do, like what's been happening is that, yes, we have like one in 1963, and then we have like a couple more over the next several decades. And then George Bush, and then we start seeing, well, okay, 8, that's a lot. And then we start getting to, Obama, it's a little bit more. And then we get to Trump, and it's a massive amount. And then we get to like Biden, and it's like a little bit, I guess. And then we get to Trump's second term, and it's a massive amount.
That demonstrates that it's nonpartisan, right? And a large number of the nationwide injunctions granted against Donald Trump were by Trump appointees and Republican judges. So it's not like there's this partisan conspiracy, right?
You're alleging the partisan conspiracy. You're saying this Supreme Court has a partisan conspiracy to help Donald Trump.
Not a conspiracy. I'm saying it's plainly partisan. This decision is partisan, right? Hold on. A conspiracy is like all the federal judges have a weekly meeting and they're like, okay, guys, this, today, how are we going to, make Donald Trump's life hard? Like that's not happening, right?
If there's Republican judges that are issuing the injunctions, why would they, like the Supreme Court, be acting partisanly when they say universal injunctions are the thing?
I mean, I can go through why I think this is partisan, right? Because they had plenty opportunities to do this under Biden, and they chose not to.
They had the same court.
By the way, the makeup of the court has changed, right, significantly since Donald Trump was elected the first time, right? So, like, we're not talking about the same court in the past as we are now, but it has been the same conservative justices during the Biden administration as it is now, right? So these exact same judges had plenty opportunities to address what is a significant problem, right, that you've described, right? A significant growing problem post-Trump 1, where we've already seen 50-some whatever injunctions.
Yeah.
Right.
So by the way, it's primarily a problem with Trump, not that much with Biden, because we got 14 with Biden. We have that much or more already with Trump. 4 years compared to what? 6 months now?
Yeah. And so this problem, right, according to you, this problem has already manifested as of Biden administration. This problem was already there. This is the exact same court, or the exact same conservative justices, right, on the court. And they had plenty opportunities, 14 or whatever, right, during Biden's administration.
They could have done it during Trump
this
too.
Issue.
Couldn't they address it during Trump's first term too?
I'd have to go through the history of like when the appointees were appointed.
Whoa. During Trump's first term, he had a majority in the Supreme Court. Maybe it wasn't 6-3, but he had a majority.
Yeah, not a 6-3 majority.
Okay, right? But he won 6-3, so he would have won 5-4. So why didn't the Supreme
Not
Court?
necessarily, right? You don't know how a different court would have ruled, right? If we're talking about the partisan outcome of a court, the makeup of the justices is, and they, by the way, Supreme Court justices like convince each other, right? Like that's the whole process by which they.
But you can use
make
that
decisions.
argument for Biden versus Trump, right? So like that is a good point, and I agree with your point. But you can say that their opinions have changed since Biden to Trump for the reasons that Lactoid is saying. But I do have a clarification question.
Just real quick, I
going
do
back
got
to
to
my
make a little
case.
money. I do got to read my super chat, and I'm going to give the mic to you, I promise. But let me read the super chat out from Zetsway for $10 to say, if something is, quote unquote, plainly unconstitutional, you don't need a preliminary injunction. The courts can rush to hear the merits if it really is that plain and obvious. Thank you for that $10. Tristan, take it away.
Not if the loser doesn't appeal, but
I'll quickly
that's another problem.
Yeah, I'll talk to the super chat for a second. So the argument here isn't whether injunctions should happen. We're just disagreeing on who should have the power to do so. So that's really what it is. So you are correct, but we just disagree on who has it. But my consistency question, I want both Radical and Mike to answer this. In my example, do you think that it was okay for Texas, even though it was later shot down, but there was a time where it went through the injunction where the birth control company had to stop selling all their birth controls to all 50 states. Are you morally okay with that?
So I don't know the details of the facts of that case. What I will answer is I am morally okay with a federal judge in Texas issuing a nationwide injunction, assuming that the law is unconstitutional, right? So like I'm okay with that. Like,
so in this case, and I'm trying my best not to misrepresent it, that it was against the FDA, and they were saying that the FDA they approved the drug when they shouldn't have, even though the drug's been on the market for 15 years.
Okay. I mean, you say they were overruled at the end, so the judge was wrong.
But when we went back in this discussion, we were talking about how does this affect different parties, and Lactoid was saying you can make a case that it will always affect someone in some different way.
If we're concerned about federal judges getting it wrong, then like they just can't rule on anything ever, right? I mean, this is
no.
This would be the same even if it's not universal.
Whoa.
No, that's reductive. So here's my follow-up question. Don't you think it would be better if Texas could do injunctions only for Texas, where someone in New York that wants that birth control pill could still get access to that birth control pill? Isn't that a better system than just doing it blanket-wise and still maintaining the ability to do it blanket-wise? It's just a little harder.
I mean, like I said before, the geographic restriction just doesn't work, period, because people move across state lines so freely, right? So,
but no, that's even more important. You can go live in a district that appeals to your sense of morality and politics.
That's an argument for federalism, right? For state, like how states can pass their own laws, but the federal judiciary is they're all within one Article 3 system, right? Yeah. So you can't say like, well, the FBI in Texas can't arrest someone in Mississippi, right? Like it's all one FBI.
But the
right?
Texas police,
I agree with Mike.
I see what you're saying because they're federal. Yeah, fine, that's fair. That's fair.
Okay, $50.
It's a federal thing.
While we have
go ahead.
While we have a little bit of time, right? $50 from Pondering Politics to say this. Just popped in. 1. Biden Department of Justice repeatedly asked SCOTUS to address nationwide injunctions, but they declined. 2. Gorsuch said in a concurrence he wanted the court to do so. And 3, Amy Coney Barrett conceded that nationwide injunctions plagued the Biden administration as well. Thank you for the $50. And that is to the point of partisanship and when they decide to hear it and why now and not during the Biden administration. Thank you.
Yeah, exactly. And another example of partisanship, by the way, is this court had the opportunity in this case to address the merits of birthright citizenship, right? They could have, because the issue before the court is whether a stay is appropriate. And one of the issues that you have to analyze in a stay is the likelihood of success on the merits, right? So the court could have, if it wanted to be nonpartisan and get rid of nationwide injunctions, right? The way they could have done it was say no nationwide injunctions, but we're also going to reach the merits of this case. And we're going to issue a ruling that says that this executive order is unconstitutional, meaning that would be precedential over all lower courts, so no one else has to really litigate the issue anymore, right? That would have been a nonpartisan way to get rid, to one, address the merits. And if this court, for whatever reason, thinks that the executive order is constitutional, they at least have to say it, right? But like they ducked it. They intentionally, like that is the only way they could, with a straight face, right, permit this to happen, because they could have easily gotten rid of nationwide injunctions and ruled the executive order as unconstitutional.
Would
I-
you
I
That
just-
was
have agreed
within
with
their
this under
ability to
Biden?
do.
I need to ask a quick question, Mike. Let me ask you this. In 2018, when the Trump's DOJ asked the court to limit the use of universal injunctions during his travel ban case, why didn't they take up that issue, despite the fact there was a conservative majority in the Supreme Court? When the Trump administration asked the Supreme Court in 2018 to address the issue, and they didn't.
What was the resolution? Like, how did they resolve that case?
They did, I
Because-
don't recall specifically, but they didn't touch universal injunctions.
Yeah, well, so my guess, without having read that case, my guess is, and I don't know, 60%, 70% sure this is right. In general, the Supreme Court is restrained on these big rulings, right? They don't want to shake up everything. So if they can find a resolution, right, that favors Trump without getting rid of nationwide injunctions, they would do that, and they did probably, right?
No,
But-
hold on, wait. During Trump's first term, he was hit by a record number of universal injunctions, far more than Biden was, far more than Obama was, far more than Bush was, like over 50 to 60, right? And during this first term that he kept getting hit over and over again with universal injunctions, in 2018, his DOJ asked the Supreme Court to address universal injunctions, and they did not.
How many of them
You're
affirmed?
saying,
How many of them affirmed the underlying injunction, though?
again, I don't know exactly the details.
So
of the
if the
underlying
Supreme
injunction.
Court,
hold on, wait.
If the Supreme Court,
But it's irrelevant,
Well,
though, because he's getting hit
No,
with
no,
all
it's
these
not.
universal.
Hold on. One at a time. You're both trying to talk at the same time, and I can't follow the points here. So, Lactoid, finish your thought, and then once you're finished with your thought, uninterrupted, Mike, respond to the thought.
Sure.
Please go ahead.
So this specific case, as to whether or not this specific injunction stood, I think is more or less irrelevant, because they also could have addressed maybe this specific injunction without addressing universal injunctions when it comes to this case. But in this case, they addressed the Trump versus Casa. In this case, they addressed universal injunctions. And you were saying, well, this is obviously partisan because they didn't address universal injunctions when the Biden administration asked them to, when Biden had a very low number of universal injunctions, that 14. But obviously, when Biden asked, clearly that demonstrates some kind of partisan nature. But Trump in 2018, his DOJ asked the Supreme Court to take a look and limit universal injunctions, which they did not do. If this court is so partisan, and he had a conservative majority, if this court is partisan, it seems odd to me how this court in 2018 refused to address universal injunctions, and this is like all of a sudden not rebutting evidence to the partisan nature of it, but they didn't address it when it comes to Biden, but it keeps getting more and more of a problem, and then they finally addressed it now, and this proves that there's some sort of like hyper partisan towards Trump. I don't know. It seems pretty. The evidence.
I'll answer that. The reason why it's partisan for the Supreme Court to address nationwide injunctions in this case specifically is because in this case, getting rid of nationwide injunctions is the only way the Supreme Court could have given Trump what he wanted while maintaining a straight face. Because the other way would have been to rule that the executive order is constitutional. Like, they just can't do that, right? So without ruling that the executive order is unconstitutional, right, and without approaching the merits, the Supreme Court the conservative justices were so careful to not touch the merits of this case. So how do you, let me ask you this. If you wanted to say that Trump can do what he wants to do without touching the merits, how else would you do it? You have to say nationwide injunctions are not available, right? In the way that they've...
No, I'm sure I could sit down after like an hour and I can come up with some sort of convoluted way where this specific situation can be like twisted to like favor Trump.
Without touching the merits at all.
Without potentially, with that, maybe you could even like tangentially touch the merits without actually addressing the underlying issue. The Supreme Court is incredibly creative when it comes to punting the issue. Okay.
Yeah, but this is an incredibly simple. It's a simple issue, though.
Well, universal injunctions?
No,
Birthright citizenship.
The executive order is a very simple order.
Say more about it? Is that the assumption here, or is that they didn't say something about it while adjusting the injunctions?
They didn't say something here, even though they could have. Right? And why not? And why resort to this extreme decision, right? That they had multiple opportunities to, sure, under Trump, sure, under Biden, right? Why in this case they chose to do it on the most, and of all of the nationwide injunctions that have been granted, right? Maybe you could argue, yeah, it's constitutional, yeah, it's not. This is one of the most blatantly unconstitutional executive orders, right? Like, why choose the one that you really just can't defend with a straight face on a constitutional level to get rid of nationwide injunctions, because that's the only way you can give Trump what he wants.
I don't
They
know
could
about.
also strike it down and then ask Trump to come back with a different one, which they did in the travel ban case like twice before he came back with his third iteration that was finally accepted. So like this conservative,
Yeah, so if that was the limiting,
supposedly partisan Supreme Court is more than willing to strike down Trump's specific cases and say, yeah, you can do this. You guys should do it differently.
$20.
Trump one is a very different political environment
Yeah,
from Trump
just
two.
real
But
quick.
go on. Yeah.
Pondering politics for $20 to say, is Lactoid's position seriously a thing later in time can't be partisan if they didn't do that partisan thing earlier? End quote. I guess
That's
Harry
his
Reid,
argument.
hold on. I guess Harry Reid nuking the filibuster in 2013 wasn't partisan because he didn't do it in 2011? Question marks. Thank you for the $20. Now you can respond.
No, the point that you guys are making the point. Isn't it convenient that they didn't do this during the Biden administration, because that would have benefited the Biden administration? The reason why I'm bringing up the first term of Trump is, if that's the argument and they're interested in helping Trump do his shit and accomplish his agenda, it seems odd that they also refuse the Trump administration when the Trump administration asked them to limit universal injunctions in the same way the Biden administration did. During that first term, they refused to do so. What it seems like is that they didn't want to touch the issue, probably because it's a complex issue. And finally, now that we have a record number of universal injunctions in this second term of Trump, that just like everything else pales in comparison, they finally came to the conclusion, we have to address this issue. And then they addressed the issue, and they found that it was not what Congress intended with the Judiciary Act. And so all these injunctions, all of them were against the law.
I mean, first of all, if Amy Coney Barrett is right, and I don't agree with her, but if she's right, it's actually not as complex, and it doesn't take, 10 years for the Supreme Court to come to this conclusion, right? But number two, why pick this? You said there are tons of nationwide injunctions granted, universal injunctions granted against Trump this term. Why pick this one? Right? Why not get rid of it in any other case? Right? Like, this is the one.
Pick it for some case.
Yeah, but because this is the only way for them to allow this executive order to continue, right? To percolate through the courts, whatever that means, right?
No. It's not the only way. They could rule it constitutional. They could rule the executive order constitutional.
Yeah, but they can't do that with a straight face, right? Like, that's why they're not even touching it, right?
Well, here's
wait. Are you saying they're never gonna rule on it?
Yeah. This logic makes no sense.
They could never rule on it if the government loses in every single district court and the government never appeals, right? Then it's never going to reach the Supreme Court.
Okay.
And also, you can't even get a nationwide injunction.
Hold on, just for my edification here. So what you're saying is that, because I haven't even considered this. So assuming that in all the district courts, the government loses their executive order cases, right?
Yeah. The winner can't appeal.
The government,
they can't appeal their win.
If the government,
can just keep enforcing the executive order.
Let me get my thought out, please. So if Trump simply does not appeal at all, and now that this injunction decision has come down, unless a state issues an injunction, right, for their specific state or for the class action, then this executive order would hold, assuming the SCOTUS declines to hear the case, or no one appeals it, so they just decline to look at it. Is that an actual possibility?
They're going to hear it in October.
Yeah. I don't think they will. I don't think SCOTUS will decline to hear the case if it comes before them. I was like,
really?
No. But the case would never make it to SCOTUS if the government always loses in the district level, in the district courts, right? If the government loses, if every single judge says this is unconstitutional, and we are, as to the plaintiffs, right? And the government just keeps getting sued, and the government keeps losing, and the government never appeals that loss. And let's say one federal judge gives the government a win, and then they appeal it to the Court of Appeals, right? The Court of Appeals is going to say this is unconstitutional, and then the government doesn't appeal that. The issue never gets in front of the Supreme Court.
But it's not enforceable where all these judges are ruling against it.
Well, it's enforceable onto anyone who's not a party to the lawsuit.
But all it takes is a single time, like the government winning, and now it's potentially enforceable to that group of people, and then it goes to the Supreme Court. But if you're saying that every single time the government loses, then it wouldn't need to go to the Supreme Court because they win every time.
No, I'm saying
the government loses every time.
It never would. So the only way this case gets to a Supreme Court is if at least one federal judge rules that the executive order is constitutional, and the Court of Appeals also rules that en banc that the issue is constitutional. The executive order is constitutional. That's not going to happen. Okay, like I'm confident the federal judges are not going to rule the executive order constitutional. The government is going to lose every time a plaintiff comes to the court and says this executive order is unconstitutional. If the government loses every single case and never appeals, then this case will never get before the Supreme Court.
I understand what you're saying, but what you're saying is like, it just seems nebulous to this conversation. Because yes, if it never gets appealed, because the government loses every single case, then the law is essentially dead. It's not applying anywhere because all that needs to happen is for like it's like a class action or any kind of lower court judge to like rule this way. And then perhaps if one of them is brave enough, I guess I would disagree with them, but brave enough to rule in favor of the government, then this will go to the appeals court and then they would strike it down. Well, now for that entire area, like it's just dead in the water because that's case law that you can then cite. And then you're saying, well, what if the appeals court then rules in favor of the government? Right. What if the appeals court then rules in favor of the government? Then yes, it would go to the Supreme Court. But all this is moot because the Supreme Court's going to hear this case in October. And if what you're saying is that this was a partisan win that they gave to Donald Trump on this specific issue, because you keep talking about it being this specific issue, like why, if they wanted to give him a win, they could just rule in favor of him on this executive order now. Unless you're saying they're obviously going to rule against him on the ruling in October, which they're definitely going to do. And if that's
the case,
what case
are they hearing in October? What's that case?
They're going to rule on this. My understanding is they're going to rule on this issue in October on this the idea of the executive order on birthright citizenship.
Just as a housekeeping aside, hold on, I forgot to do this earlier, but I just invited you if you want to share chat. And if anyone else is streaming on Twitch and wants to share chat, just let me know and I'll invite you to. Anyway, carry on.
Okay. So your logic would necessitate the idea that the Supreme Court favors Trump in such a partisan way when it comes to this birthright citizenship issue that the most they're willing to do is give Trump a few months in which he said he's not going to enforce this rule until the Supreme Court rules on it anyway. That doesn't make any sense.
Why is the Supreme Court ruling on this on October? Like, what case is being appealed where this is an issue?
I'll take a look. I'll find this. I'll find this for you.
My understanding is, can I ask a question?
I'm only asking because at oral argument, the justices brought up this issue. So I'm assuming the Supreme Court justices are aware of their docket.
My understanding is it's going to be, and maybe I'm wrong on this. I'll look at it. I'll find you what I was thinking of. My understanding is it's going to be ruled in October. But even if it's not, right, the Trump administration is not enforcing this, right, until the Supreme Court is going to speak on this, right?
No, the Trump administration can start enforcing this within 30 days.
And they're going to lose.
The executive order.
And you're saying they're going to lose every time up until the Supreme Court decides this.
Well, if they lose every time, it'll never be before the Supreme Court.
Well, why would it need to be in front of the Supreme Court if they lose every time? But
it's
still going in front of the Supreme Court.
Yeah,
but why would it need
because you're still requiring all of these people with temporary legal status to sue the government in federal court just to get relief for their one baby.
And,
right?
and to be clear, to piggyback off that a little bit, remember what ICE agents do to people who go to federal courts? They deport them.
Yeah.
So the thing is, yes, technically, if you go to the federal court to bring suit, that court, the district, can for their district make this injunction, but they have already staged the ground and set the stage that it is very, very unlikely that anyone seeking relief from this, an illegal immigrant, right, who is seeking to have their child gain citizenship by being born here, would pursue this through the legal court avenues. Does it
and not just illegal immigrants like mothers?
Am I wrong here?
Yeah.
It sounds like a great time for a class action lawsuit.
Yeah, but first of all, that's assuming, right, that the courts are going to grant and that the Supreme Court is going to affirm a class certification for basically every single undocumented person and temporary legal status.
Doesn't the Supreme Court only have to affirm it if it gets challenged?
Yes, but it's gonna, right? if a district court grants class certification for every single undocumented person and every single person here on a temporary status, right, the government is immediately going to appeal that. that issue is going to get before the Supreme Court one way or the other, right? So assuming that's even possible, and I'm not even convinced it is, right? First of all, I'm not convinced that you can get class certification.
I'm having conflictions here. In one sense, when it's favorable to you, you're saying that it won't get to the Supreme Court, but then under the class action, it would. Wouldn't that make the class action better?
Because the government loses. No, so in the class action sense, right? Like, it's hard to come up with an analogy for this, right? But if I sue on behalf of a class and I win, right? I win as in I get certification, then the loser can appeal that decision, right? And then that's going to go up and eventually get to the Supreme Court.
So you're saying they'll hide behind the lack of certification to not rule on it, is what you're saying?
No, the Supreme Court will rule on it if the issue gets appealed to them, right? They almost certainly will. They'll take it up. I'm not accusing the Supreme Court of sort of burying their heads in the sand and refusing to hear important cases. I'm saying procedurally, if the government loses, right, in every single court on the constitutionality of the executive order, there will never be an opportunity for anyone to appeal the case at all. The Supreme Court can't just come down and say okay, we're going to decide constitutionality of this executive order, right? It's limited to cases and controversies. Well, if there is no controversy before the Supreme Court, they will never have the opportunity to even weigh in on it.
Okay.
I'm not.
Okay, let's.
I don't have a response to that, but I do have a question. I've been sitting.
Go ask the question, please. Let's keep going.
It's also for pondering politics. If you're still in chat, but you guys brought up that Biden wanted to address this during his term. Would you guys have agreed with this if it happened under Biden?
No, but I don't agree with it now either. I just don't agree with getting rid of nationwide injunctions. Period. So.
Okay. Do you think that this would disappear once Trump's not in office?
Do I think what?
This ruling on injunctions would disappear once Trump's not in office?
He leaves office.
No, it's permanent, right? I mean, as long as this is the makeup of the court, right? Mm-hmm. Yeah, long term, this is precedent, right? There are going to be very, very limited instances where universal injunctions are granted, because the Supreme Court did leave, possibilities for that. But yes, it's good. It's good law. It's precedential law. It's going to be that. That's going to be the case going forward.
So what is, I guess for Radical and for Tristan, what's the fear here, right? So we have precedent law that was set, right? Whether you agree with the reasoning or not, what's the fear here? What do you think is going to be done with this? How is it going to hurt people?
So, I think Mike laid out fairly well, how it's going to put put a lot of people who are being born here during this kind of uncertain period in a difficult position where they've got this purgatory of citizenship. But also I feel like this my fear is that this kind of rewards an executive branch that is ruling more through executive orders than legislatively. That's kind of the
you fear it'll incentivize other administrations in the future to simply bypass Congress and simply use executive orders because it's much harder to stop by the courts.
Well, yeah, I mean, it feels like that's already going. That is kind of like the precedent that's set with Trump, and that's something. Obviously, that's why there were so many more injunctions during his first and now, because he does that so much more. And again, I think he does it and kind of plays with the edges of the law, at least as I understand it. But yeah, I think it sets that precedent. Do you not think it rewards that sort of behavior more so than a kind of slow and steady legislative approach, by trying to do bipartisan passing in the legislative branch?
I'm with you. Executive order bad, right? And to I guess.
Well, yeah.
I'm just trying to generate discussion because the other side has gone silent, and so I'm trying to engage with you guys.
I was just looking at
okay.
Where the October thing comes from Pam Bondi. Pam Bondi said at a press conference that she expects the Supreme Court's going to make a ruling on the merits in October of 2025.
Yeah, but what case?
Now. The merits of this birthright citizenship matter. No, she didn't specify a specific case.
Okay.
That is again a pretty high up official saying that that's what she expects.
She also said she had the Epstein files on her desk and it was going to go there too. So I mean,
but fair enough.
It's Pam Bondi.
No, I understand, right? But so you're right. So essentially, then, what I understand your concern then to be, Mike, is that despite Pam Bondi saying that it's going to be a rule in October, we can't trust her. So the Supreme Court, it's not clear whether or not they're ever going to rule on the merits unless the issue comes in front of them. And you're saying that, well, in the meantime, the government could just lose every single time and then just like refuse to appeal at the district court level every single time, and then this is just like the new status quo. You think this is like what the administration is going to do?
Yes, I think the administration
You
is
don't
not
think
going to
they're gonna
appeal when
appeal?
they lose. No, I don't think they're going to appeal when they lose. I mean, I'll eat crow if this comes before the Supreme Court because the government loses. And let me be clear: the cost to the government of not appealing is so small. Assuming we don't get class certification, right? It's like 1,000 people, 2,000 people in a lawsuit, because like depending on the organization, and also assuming we get third party standing. I mean, that's all complicated, but really, basically speaking, even if a district court grants an injunction now, it's only going to cover a very small number of people, right?
Not
It does not.
necessarily. If it's a class action, which a lot of them have already moved to class actions.
Yeah,
following
well,
this case.
if they get okay, if the courts grant class certification for like basically all undocumented people in America, then yes, this is going to go before the Supreme Court, 100%. Okay,
I want to.
now
No,
maybe
it's going in front of them either way.
well,
This is a
maybe
bet I want to make
maybe the
with you.
class certification is gonna go.
Okay, I want to.
If real quick, if
Okay.
the executive order is attempted to be applied to the country at large, if he actually tries to say like make it the case that birthright citizenship doesn't apply, there's no way this doesn't go in front of the Supreme Court. There's just no way. Like on a merits question, you really think that they're not going to appeal that? You really think this doesn't get in front of the Supreme
Well,
Court?
why wouldn't they have addressed it now? They could have. They
Because
have
the
everything they need to address.
No, because the very
The
specific
questions
question
before
was
them.
no,
The
but
specific question
very
is,
specific
should you
ask
grant a
was
stay?
injunctions. Yeah, the very specific question was specifically when it comes to universal injunctions.
The government asked for, but the court can take up any issue sua sponte if it's before them, if it's within the case of controversy before them.
Sure, but
they don't have to. They don't have to. I agree, they don't have to, but they easily could have in this case. They easily could have resolved the question in this case, and they chose not to.
I would agree.
And why not? Right?
I would agree. Right. Well, it could be because the specific case, like they wanted to address specifically universal injunctions, because that is the thing that's preventing them.
They could do both.
Going forward.
They could do both.
They could do anything that, like they could rule however they wanted to. They could add more things under the ruling as well. You're right. They potentially could, and they don't have to. The Supreme Court does have a tendency to only rule on like the very narrow questions that are asked of them. They are perfectly willing to kick questions down the road all sorts of times. This isn't new for the Supreme Court. The question is, now that we have universal injunctions removed, and this is moving towards class action, and of course, like the government's going to appeal when they lose, even if it's not a class action. Of course, this is going to be what's going to happen. Of course, it's going to go to the Supreme Court. And if they're actually put in the position now where they have to answer the merits question, they're going to answer the merits question. I agree. They're probably going to rule with the way that you see it. They're probably going to rule that birthright citizenship is protected amongst the children of illegal immigrants. I've heard the arguments to the contrary. They do exist. Like you can point to things to make the argument. I think it's a little bit of a weaker argument. But yeah, like the fact that you really think the Supreme Court's not going to address a 14th
once
Amendment
he responds, I'm going to let Mike respond. Then
Okay.
Tristan's trying to get in, and I got to let Tristan in. So Mike respond, and then Tristan wants to get in on here. So go ahead, Mike, and then Tristan.
Okay, if I had to do a crystal ball prediction, I do. There is a chance this ends up before the Supreme Court, but the way it happens is I'm going to guess, because in this case, the court remanded to the district courts the question of whether a universal injunction is appropriate as to the state litigants. If the district courts grant a universal injunction as to the state litigants, that is 100% going to be appealed up through the courts, and it's going to end up before the Supreme Court. And the Supreme Court will have at least two questions. One is, can the states sue? Do they have third-party standing to sue on behalf of their people? And also the merits question, right, of whether the executive order is constitutional or not. At that point, right, the Supreme Court could hear it. But I don't put it past the government to, if they don't get the state thing, right, and it's just 10 people here, 50 people there who get an injunction. I mean, why would the government appeal? Like they're winning. But go on, Tristan.
Well, hold on. They're losing. You're saying why would they appeal? They're losing, but they're really
They're-
winning because they're just going to lose
they
every single case.
Yeah, because not everyone's going to bring a case.
Millions
Not
of
everyone
yeah.
has the resources.
Whoa, you don't. There's of course going to be like pro bono, pro immigration, like pro left wing law interests. They're going to
Class
take like
actions.
hundreds and hundreds, even if they can't get a class action going, they're going to take hundreds and hundreds of plaintiffs because all their cases are going to be substantially similar. And they're going to be filing all these cases. And the idea is, well, the government is just going to be bogged down by like really, I think by hundreds of thousands or millions of cases. And every single time they lose, they're going to lose in every jurisdiction and they're just never going to appeal. Like that's
Well, the burden on the government is
so
low.
unrealistic.
The burden on the courts is a little bit higher, but what's going to happen is everyone's going to have a complaint, right? It's going to say this is unconstitutional. We have personal jurisdiction this way, so on and so forth. And the government's going to send an answer, deny. The court's going to rule. Okay. But then first of all, even hiring a lawyer, we're talking about millions of people, right? We're talking about millions of people
who all substantially similar case, all of them. There
are tons of people right now who need pro bono representation who can't find a pro bono lawyer. Where are all these lawyer hours coming from, right? People
on this specific issue, this politically charged issue, where all their cases are going to be substantially the same, all the legal arguments are going to be substantially the same. Hey, birthright citizenship applies here. This is basically the one argument you got to put forward. And we're also assuming that they don't get class certification, which I think in certain jurisdictions they probably would, right? They've already moved to, but for the next 3 years, the policy is just going to be they're never going to appeal these hundreds of thousands of cases, and it's going to keep on cycling until they get every single illegal immigrant off when it comes to, or I guess not illegal immigrant at this point, when it comes to children born of illegal immigrants. Now, all of them are guaranteed citizens because they have each won their individual cases, and the Supreme Court's not going to take this up.
I am less confident on the Supreme Court thing, but I am 100% confident we are not going to see a million lawsuits for all the individual plaintiffs.
Hundreds of thousands.
I'm 100% confident.
Assuming the Supreme Court.
Okay. I do have to give it.
Assuming the Supreme Court doesn't hear it, and assuming no class certification.
Hold on.
Of course.
I do need to give it to Tristan. He's been very patient, right? He's trying to get in here, and I love the back and forth. I love the energy and things like that. And this is an important question, but Tristan does need in. So go ahead, Tristan, please.
All right. So I want to go back to Radical, give him some time as well. So one, I want to say that I share your fear that Trump will abuse the ruling. But generally speaking, I think that he will abuse anything, right? So I'm gonna start there, and then second, I want to test you to see if your issue is because it's Trump and what he will do to it, or if you have an issue with the procedural ruling in itself, right? So going back to that Texas case, do you think that it was okay that a company was able to shop around for a judge to target a specific birth control pill and then have that banned federally through an injunction? Would you morally?
I think I agreed. Okay? I agreed with. I liked. I don't have the background to say for sure, but I liked. It felt right, what Mike was saying about that question, which is it makes sense that if it's ruled unconstitutional, then that's.
But there was a time period during that case where there was no ruling on it, which is where we are right now with the whole birthright citizenship thing. So it's pretend that ruling never happened. Do you think that it was okay that they were able to shop around for a judge, have that judge make a ruling that affects...
Okay. I'm not saying it's not problematic, but I feel like this, I could be wrong. I feel like this creates more scenarios like that. No? It's just inverted?
Yeah, it would be inverted.
Can you elaborate on that, Radical? I'm not sure I understand what you mean. Sure. When you say that this creates more problems but inverted, elaborate, please.
Yeah. So specific, more situations where there's this uncertainty period. I guess maybe I am assuming that there's maybe part of it is because it's Trump, but it's not just because he is the orange man, but it's because of the nature of how he is engaging in the law. The way again, it comes back to this excessive executive order stuff. It seems like he has more room to set up these laws. To set up these executive orders where then people are going to be impacted by them in really serious ways, whether they're constitutional or not, for longer periods of time. I just feel like that's going to happen more and more is what I'm trying to get at.
But wouldn't that be true on the opposite end? Like, so I mean, it's like I feel like we can go through a list of injunctions that's happened over history, and I feel like we can go through them and pick out, yeah, this is something I would have supported. This is something I would have disagreed with. Shouldn't we be focused on the procedure itself, whether it's a good procedure or a bad procedure, and not what could happen, like good or bad? Like I understand we can't have perfect laws.
Well,
Someone is always going to win.
Yeah, well, I guess
someone's
this
always
is
going to
why
lose.
this is why I wanted to. I was asking about like the practicality question, because I mean
Well,
I feel like we
go
have
ahead.
to. Yeah, sorry.
No,
Go ahead.
it's
Yeah,
fine. Finish.
I feel
What's the
like it
practicality
wasn't addressed
question?
earlier. Like, well, just that like it seems like there's going to be a lot of people put in this purgatory like more often right now. I don't know. That's just my feeling. But that's yeah. I don't know if
Can
I
I
have the
ask you a
right words to
question?
describe what I'm concerned about. Yeah.
Let me ask you a quick question. If let's just go with what you're saying. Let's say it's the case. It'll happen. Do you think that is relevant to what the law actually is? Like, if the law happens to have a bad result, like is that bad result an argument against the law being what it is, or is what the law is like what the people who made the law intended the law to be?
I think there's maybe room. Like
It could be
I don't
both.
know. I don't know if I have
Because
yeah.
ultimately the question is like, can Congress
I think
pass
that
bad
if
laws?
like okay like if for some
Yes.
reason like the Supreme Court like if there was like some like I don't know, the Supreme Court was going to make up some ruling that was just like absolutely disastrous for like a bunch of people. I think that which I think it sometimes does. I don't know. I think we should consider that. But like regardless of what the originalist framing is, yeah, that's my
The
gut.
problem I have with that is like you could have a situation where let's say Congress could just pass like 5 days ago, pass a law that you would consider to be disastrous. Like obviously we think that Congress should be allowed, like this is part of democracy. Congress should be allowed to pass bad laws as long as they're not unconstitutional. And so if Congress passes a bad law that happens to have negative effects, or I guess what you would deem to be negative effects, right? Some people actually really like the idea of not allowing the children of immigrants to be citizens. But what you might see as like a disaster effect. For me, the question of what the law is. Yeah, go ahead.
So I'm just curious. Does everyone here like? Do we all agree that like birthright citizenship should probably remain, or are we? Do we not all agree on that?
I
think it should remain because it's in the Constitution.
Yeah, I think that at least I didn't put together a birthright citizenship panel, right? We're talking about the injunctions.
Yeah,
the birthright citizenship as a concept, that's a tangential to the question, right? But the question before us today is whether or not the SCOTUS ruling getting rid of, basically, except for in very narrow circumstances, universal injunctions, was well-reasoned, whether it was good, whether it will have good effects or bad effects, regardless of the legality of it. That's what we're here to talk about today. One thing that I've noticed, and I want to give it to Mike for a little bit. He's been, give him a little bit more of a chance. And again, not a lawyer, so please correct me if I'm missing something obvious here. The question at hand on universal injunctions seems to be, is irreparable harm more important to be concerned about when it's done against the government or when it's done against individual groups or the citizens of the government or the people under the government's jurisdiction, right? Because what the argument seems to be, at least in the case law, or the case, is that the government would be irreparably harmed by certain injunctions, preventing them from carrying out their duties for however long it takes to get for it to go up the courts and get ruled on. But the reason, at least for universal injunctions, is to prevent irreparable harm against the citizens of the country. Am I misreading this? Am I getting this wrong? Why am I incorrect in my kind of view of the situation? Go ahead, Mike.
You're not wrong, but it's not a binary question of do we care more about harm to the government or do we care more about harm to the citizens, right? Like what I would advocate for is for the courts, and this is what the courts have historically done, is to weigh how much is the government being harmed and how much is the citizenry being harmed, And how do we weigh these two things against each other, right? Because sometimes the government is harmed a lot and the citizen is not harmed as much, right? And sometimes it's the opposite. But in this case, right, the court skipped that analysis. Right? They said, we're not going to think about that. We're just going to say anytime the government is prevented from doing what it wants, it's irreparably harmed, right? And the state analysis has 4 factors. One is harm to, basically 2 of them is harm to one side versus harm to the other side, put simply, right? There are 2 other factors about public interest and one more thing I'm blanking on. But 2 of the state factors are typically you weigh the harm to both sides and you consider it. This court did neither, right? This court did not confront the harm to the American people. And those people, in this case, being infants, right, born who are entitled to citizenship under the Constitution, versus, right, the harm to the government, which is, I don't even know what the harm to the government is. If we had, other than just saying, well, they can't enforce their law, like how is the federal government being harmed, economically? I mean, maybe emotionally, but like, so the court skips that analysis, right? It's an inconvenient analysis for them to go through. And Sotomayor points this out. So, I think to answer your question, Wick, is yes, we do care about how much each part is harmed, but until today, the answer has never been the government always wins or the people always wins. And now it's on the harm analysis, the government always wins.
Okay.
So, Mike, I think
no, hold on. On a specific injunction, it is not the government always wins. All this did is just remove universal injunctions. Like, let's be clear.
Well, no, on the analysis of, they were very clear in this opinion that anytime the government is prevented from doing what it wants to do, right, it has suffered an irreparable harm.
Yes, and you would agree there is some level of irreparable harm that's suffered. You could say, like in a specific injunction matter, perhaps that harm is outweighed by the specific harm to a different person or different party, right? But you would agree that in every injunction there is an irreparable harm to the government to some degree.
No, the redressability analysis is fact based, right? Sometimes the harm is irreparable, and sometimes it's not. Or in this case, you could just deport. If this case, if the executive order becomes constitutional, the government can just deport the people, right?
But you could deport them 20 years from now. Well, hold on. You could say, you could repair it 20 years from now. But in the meantime, it's irreparable, right?
Well, then every harm is irreparable, right?
That's what they ruled. That's what they ruled.
And that's why it's wrong, because in legal analysis, why would we specify irreparable harm if every single harm is irreparable? Like, what's the point of going through that analysis?
No, I'll explain. I'll explain, because they specifically referred to, when it comes to the government, that it's always like some level of irreparable harm, because having to do with democracy, having to do with the fact that a policy is being passed, and then by being stopped during that time period that it's being stopped, there is like a level of harm that is irreparable. In a specific injunction matter where there's somebody else who's like looking for an injunction, right? That perhaps the harm could be seen as lesser than the other person's harm. That's fair, right? But there is some level of harm. And they didn't say that for specific injunctions that like it is always the case that the government has like wins on that matter. They didn't say that.
I mean, that's 100% new law and contrary to history, right? That every time the government can't do something, it's irreparably harmed.
Yeah, that seems
like
the harm is just they're not being able to do what they want to do. Is that
during the time? Yeah, during the time.
Automatically irreparable.
Yeah. Think about it this way. If you said, well, let's say the government passes a policy, and then they are delayed 20 years from implementing that policy. I'm going to use a large time scale to like really amplify.
Then it might be irreparable.
You're saying then it might be.
Do you think the harm's the same? Hold Lactoid. Do you think that the harm is the same if they're prevented from enacting their legislation for 20 years versus 2 months?
The same? No, of course not. The Supreme Court didn't say that.
Would you consider the 2 months, if this was 2 months and this was resolved either way, would the harm, in your opinion and in the court's opinion, still be irreparable?
Yeah, there's some minimal level of irreparable harm.
The court said
there's some minimal
1
level.
second, 1 minute, it's irreparable.
Yes,
right?
Yes, which makes perfect sense. One like tiny bit of time is like that little. It's a very minimal, very very minimal level of harm. I agree. It's almost, in fact, you could say almost insignificant, de minimis irreparable harm. But the goal of government is to implement policies that the people have voted for And if you delay this by an extended period of time, this is some level of irreparable harm. And I'm just to correct what you said before, they did not say that the government always wins on this analysis when it comes to specific injunction cases. They did not say that.
No,
It
they
can
win on
absolutely
that
be the case.
issue. They win on the irreparable harm.
Stop. Do you
factor.
agree? Do you agree that it can absolutely, like in a specific injunction case, a different party could have more irreparable harm than the government? Thus, the courts could rule in favor of the injunction, not a universal injunction, but just a regular injunction.
Yes, another
Okay,
party could win on the merits, but the analysis has 4 prongs, and what the government has said is one of them, the government always wins. I'm not saying the government always wins on
Makes
all
sense.
4, but but then what's even the point of having one of them if the government automatically? It's like, if we play a game
because it's the government
and we have it's first to 4, and you automatically get 1 point at the start of like that.
Because other parties,
that's ahistorical, by the way.
No, so can you point to me case law that goes against that? Because I can point to you plenty of case law.
Every single case of it looking at preliminary universal injunctions, they go through the analysis of how the
Supreme
government
Court, the Supreme Court. Hold on, the Supreme Court will go through and they have specifically gone through an analysis of the government having irreparable harm. They've specifically gone through that because
they go through all the state factors. I don't even need to look this up to know that the court will go through every single state factor and they'll analyze the facts as they do in every single case. Right?
And you're saying in the past they have found the government has, in certain circumstances, has not had irreparable harm in getting their policy put through.
I'm pretty confident. Like I could do some research, but I'm pretty confident I'm pretty confident there have been cases where either the Supreme Court or the Supreme Court just hasn't heard as many cases as the entire federal judiciary, but certainly courts of appeals that have found that the government did not suffer an irreparable harm.
I'll take a look. I'll give you time afterwards. I would be curious.
Okay.
And you
hold on. Is your position, Lactoid, that it's never been the case that the government hasn't received irreparable harm?
I'm not aware of the Supreme Court having ruled like his.
So not
his
in
claim
a
was
single
that
time where this has been looked at the
I'm
courts
not aware
have
of it.
ruled against that the
Supreme
government
Court
has not suffered irreparable harm.
Irreparable harm. Some
I
level
don't know.
of harm,
I don't know, but that's
well, I've asked.
that seems
wait.
a lot,
I could be,
right?
I know. Hold on, I could be proven wrong here. I will await the information if it comes. I'm not going to be a dick about it. But I do. Wait. I do want to point out it's hilarious that you're going to say it's ahistorical when I can point to you specific Supreme Court cases that have specifically said that the only people entitled to relief are parties to the case. I can literally, there's a Donald's case. I can literally, the majority cited it. I can send you it. It specifically said that. I can specifically cite you the fact that Supreme Court during the Lochner era would issue thousands of injunctions instead of a single universal injunction that would have accomplished the same thing.
But they never said we're not going to do this, right? They never said we're going to do 1,000.
No, you're right. They just never did it.
Let me respond to the first point of irreparable harm. Even if, and I don't believe that the government, there's never been a case where the court found that the government did not suffer an irreparable harm. But even if in every single case the court found that the government suffered an irreparable harm, they still went through the analysis, right? They didn't just say full stop, okay, on this prong, the government wins. They have always gone through the analysis and they said, well, here's why the harm is irreparable, because of reasons X, Y, and Z, and not just because this is a democratically elected government, right? So historically, right, the courts have always at least analyzed the issue, even if they came out in favor of the government every single way, which I highly doubt.
I'm serious about this. If you find me a Supreme Court precedent on this, I can change my mind. I could say that particular part of the case sucks because I care about the history of things. And when you don't have universal injunctions for 175 years, that's relevant to me as well.
Okay, let's get Tristan. He's got his little pencil raised there, and then we're gonna after Tristan goes and go through there, we are wrapping up soon, so we'll get to closings and things like that. But go ahead, Tristan.
All right, so Mike, I do agree with you that they should have voiced more of an opinion. They are our civil servants, and I think they could have done more, and they could have even gone a step further and issued their own injunction or not. Right? They could have done that, but they didn't. So I'll grant you that. But I want to ask you, do you think that the injunction on the the injunction on the birth control pills caused irreparable harm to those who couldn't access it during that time frame? I know it's not the government, which is, what they're talking about here, but I'm just asking about the irreparable harm part.
I'd have to think about that for a second. So I don't ascribe to the argument that Lactoid made, which is basically like almost any time you're harmed, that harm is, even if it's de minimis, it's irreparable because arguably you can't turn back time, right? The harm happened. You can't turn back time and undo it. But
Well,
that's
I
not the
mean,
legal analysis of irreparable harm, right? Irreparable harm
okay.
has to mean like something that cannot be, you can't be fixed later, right? So if there was a person who suffered a harm as a result of some ruling that cannot be resolved in the future, right? Either through money or through an injunction or through undoing something,
In
right?
this
That
case, would
physically
that be
cannot be
abortion?
undone. You're saying people who were,
Let's say someone got pregnant, they were
Uh-huh.
on that specific drug, it got banned, they got pregnant. Is that not irreparable because they have access to abortion, or like what? How
it would be
how would that be
if you
determined?
deny someone the ability to get an abortion unconstitutionally, then yes, that's irreparable harm.
No, I think
Right,
what
because
he's
Okay, so
saying. Hold on,
you
let
can't
me
fix it
try
in
to
the future,
translate.
or you
Let me
can't
try
kill
to
your baby.
translate. That's not what he's saying. He's asking you
Mhm.
in the case where, as I understand it, and I'm just hearing this secondhand. Apparently, a Texas federal judge issued a nationwide injunction banning the sale of a specific birth control pill.
Hmm.
So he's asking you, for those of you of the people, because of this injunction, were they irreparably harmed by not being able to access this specific birth control pill? For me, the answer would be, of course not. They had access to, I don't know, hundreds of other birth control pills. Why would banning this specific one give the citizens, right? I'm not talking about the company who may have lost money, right? But the citizens, why would that be irreparable? It seems like they would have had access to others. I can't think of a situation where not having access to this specific birth control pill would be something. Now
Yeah,
the company,
that
you could argue the company might have been harmed, fair enough, but then the restitution isn't irreparable. They just get the money, right? They can sue for the money that they lost during that time the injunction was in place, and therefore repaired.
Yeah, you're right that certainly the company would not be irreparably harmed, and if there are alternatives, then the individual is also not irreparably harmed, right? It's can you work around it? Can you fix it? Like thinking in layman terms, right? Is there any other way to, assuming the court is wrong, is there any other way to sort of fix it, right? Either now or in the
So, is
future.
there no fix for birthright citizenship if it were to be ruled that the court order is not okay? Is there no way to fix those that were born and not given citizenship?
So I think yes, but first of all, you don't need to show for the people that they suffer an irreparable harm, right? It's a different standard. So that's a little bit nuanced. But even if you did have to show they suffer an irreparable harm, I mean, you're a baby, you're deported, right? Like the consequential harm of that is ginormous. How do you give that back to someone?
Well, we saw Abrego got undeported, right? So I mean, there. So it's like I understand it's a sliding scale.
It was
And I just
repaired.
don't. Yeah, I just don't understand why we believe what we believe on that sliding scale. You know, like how is that sliding scale determined? Is it like just individual cases on the magnitude of the cases? It's like
It is determined on an individual basis based on an analysis of the facts and the magnitude, which is what I'm saying the courts should do when it comes to universal injunctions, and not have this sort of ham-fisted approach. Right?
Okay.
I think it's a
Okay.
difficult analysis what you're asking for, Tristan. I think those are hard questions, but those are questions that the court should answer instead of punting
agree.
and say, well, every time the government's hurt. Okay.
I can agree with that.
I think this is a good time to get to closing statements. This has been a very, very high-minded discussion. I appreciate it. So thank you, all of you, for engaging and bringing your questions and bringing your comments and bringing your expertise and bringing just your sense of justice here. This is a great discussion. I really enjoyed it. Thank you to all the people who watched and commented. And if you enjoy these kinds of things, we don't always have it so high-minded, right? We're going to have some blood sports later on in the week. Don't worry. But like the stream, subscribe if you haven't already. If you feel like donating, you may. You can give me gift subs, super chats, memberships, bits, all these things really help the channel, keep the lights on. Before I give the mic over to these lovely individuals, right, to give their closing thoughts and tell you where that you can find them. And I hope you do, because they spent time out of their day to give us content, right? So go and follow them and all that. I just want to tell you what we got coming up for the week. Tomorrow, I'm going to do call-ins. Should be a lazy day. I'm looking to get a call-in co-host, but we'll see if they say yes or not. We'll see. But we will have call-ins. On Wednesday, at 7 o'clock, I'll be going on to Live and Learn with my co-host, Tali. And Tali is going to stand trial for her vote she cast for Trump. And the Live and Learners are going to act as judge, jury, and dare I say, executioner.
Oh,
I will be an advocate for Tali. Not that I agree with her voting for Trump, but I will be there to defend her and against any accusations that come forth because of her vote and her action, which I also agree is bad. So that should be fun. That'll be a nice struggle session to tune into. So Wednesday at 7 p.m. And on Thursday, we're going to have Soy Pill and Loner Box, and I'm still looking for opponents for them. So if you're an isolationist or something, we're talking about American interventionism on the 3rd, not just in Ukraine, but in Iran, in what's the other one? Israel, things like that. And so if you are someone who feels like the U.S. should get out of those places or shouldn't be involved in those places or other such things, give me a holler and we can get you on a show with Loner Box and Soy Pill. Should be fun. Okay, we're going to give the mic first to Lactoid, and then we're going to end with Tristan, and we're just going to go around. So Lactoid, closing thoughts? Where can people find you? And what are your closing thoughts on this? Go ahead, please.
Yeah, I'm Lactoid. You can find me on Lactoid TV on Twitch and on YouTube. I'm going to put forward, just after some cursory research, I'm going to put forward the claim that the Supreme Court has never, in American history, said that there is a circumstance in which the government does not suffer some kind of irreparable harm. There's some case law prior that indicates that their harm to the government actually is a factor. Cases from 2023 and cases from 2008, and government interest before that has always been listed as a factor. So that's going to be my. I'm going to challenge anybody to come up with any kind of case law to the contrary. I don't think you'll be able to find it. I think that this case is historical. I think this case, much like I like to see as an originalist, focuses very much on history. It focuses on what laws are as opposed to what we want the laws to be. It focuses on what the people who made the law intended for the law to apply to, as opposed to potential pitfalls or problems that may arise as a result of the law being the way that it is. I think that Amy Coney Barrett did a fantastic job going through the history of the United States, pointing out multiple Supreme Court cases, precedent, legally binding precedent, indicating that the only relief that people are entitled to is if they are parties to a case. There's plenty of examples that were brought up specifically where it would make more sense if courts thought they had the ability to do universal injunctions, that they didn't do universal injunctions. Instead, they did specific injunctions to all the parties listed. I think the weight of the evidence, because ultimately any kind of honest historical analysis is based on, it's an evidentiary based, it's paleontology. It's an evidentiary based analysis in which you have to add up evidence on your side and make the case. And I think that the overwhelming amount of evidence indicates that the founders, when drafting the Judiciary Act, did not foresee, did not intend for this act to provide district court judges the ability to issue universal injunctions. I think it's telling that for 175 years, this was the case. And I think that the Supreme Court ruled when it became much of a significant problem, which nowadays, unfortunately, or it was a significant problem, not a problem anymore. To the people here who debated me, appreciate you guys. It was a good discussion. Very, very high-minded policy law discussion, not a lot of ad homs, which I like. I don't like that blood sports bullshit. Really appreciate all of you. Yeah.
Thanks for being here. Check him out, gang. You can find him under my YouTube description, a link to his channel, and go give him a sub. Next up, first time on my show, hopefully not last, hopefully enjoyed it, Mike. Go ahead, Mike.
Thanks, Wick. Yeah, thanks everyone for the conversation. Thanks for having me. So I'm not a content creator, so I don't have a stream or YouTube. I did just make a Twitter yesterday. It's at Mike 2 trees, 2 being a number. And really, this is me sort of dipping my toes into political discourse because I think, I've always sort of refrained because of my practice, but now I think it's a particularly important time. I think we're seeing a lot of radical changes in government. I obviously think they're bad. Others might think they're good, but definitely important time to be talking about these things, maybe in a high-minded way every now and then. Again, I'm not a fan of the blood sport. I understand there's a place for it. So, uh, keep me out of those, but I enjoyed this discussion. I think on the substance here, Lactoid, you and I can go back and forth more on the history and originalism. I have a lot of thoughts there that we don't need to repeat here. I disagree with this opinion. I think it's incredibly harmful, not just now to millions of Americans, but moving forward in the future. I think the consequences are going to be significant. I do think, just to touch on the substantive point briefly, that the law we're talking about is a law granting courts the ability to grant relief in equity, not DEI equity, but fairness and justice, completely for everyone equity. And sometimes what's required to get equity for everybody is different as times change, as the country grows geographically, population wise, as technology changes. But the Judiciary Act was clear that complete relief is necessary. And the courts should do what they can to fashion complete relief. I agree with the restraint. I don't think we should have so many nationwide injunctions, but I do think there is a time and place for them. And this case is one of them.
Okay, well, thank you for being here. Check him out. I put a link to his Twitter in the YouTube description. Click the link, give him a follow. Why not? Maybe we can convince him to stream and give us all some content. We'll see. Next up, Radical Coder, please.
Yeah, I feel like I was just kind of like a live audience for this one, but it was still cool to be here. I feel like that meme where it's like the guy's looking out the window in the bus in two different scenarios, like it's like sad in one, and he's like, "Oh, I've got a lot to learn," and he's bummed, and then he's looking out excited at the sky. He's like, "Oh, I have a lot to learn." So that's kind of how I feel right now. Like there's a lot of stuff here that I'm curious about. Mike, I would love to actually have a conversation in the future with you. I'm super interested in what you had to say about this. I felt like it gave a lot of structure to like the kind of gut feelings that I had about the situation.
Yeah, just an open invitation. Sorry to interrupt. Feel free to reach out to me whenever. I'm happy to chat with people offline or whatever and make time for that.
Yeah, awesome. Yeah, I still I feel like that it wasn't really. I mean, I probably could have pressed this more. But I feel like this does incentivize more executive action, and like Trump already is predisposed to be doing that, so it's more likely that he can lean into that more, and there's going to be people who are harmed by that. I think even Lactoid seems to have acknowledged that there's potentially room for more harm, but like it's just legally justifiable, which is it's a, I guess, fair enough position to have. It seems concerning to me. But I'm Radical Coder. I'm not a lawyer, but I'm very curious. I actually do something between the kind of high level minded discussions and the blood sports. I like to weave between both of those worlds myself, because I don't know, I'm just comfortable in both spaces. But I also teach people how to code and fight with them sometimes while I do it. So I think one away from 800 subs. So we're inching towards 1,000 right now, which would be very exciting for me. So if you want to check me out, I definitely talk a lot more on most of the other panels I've been on. So there's a lot of content there in my backlog to check out.
Check him out, gang. Let's get him to 1,000 if we can. Give him a follow and give him a sub, whatever he needs. Thank you for being here. Last but certainly not least, and again, first time, but hopefully not last time on my show, Tristan, go ahead.
Radical, I'll definitely be subscribing. I want everyone to know that I am not a Trump supporter, despite the fact that I agree with the SCOTUS, and I acknowledge that there are flaws in it, as has been made apparent today. I still agree with it, and I think about it on a larger scale. I don't think about how Trump is just going to abuse it, because I believe no matter what, he's going to abuse it. I do think that there is a law that would be great for replacing this. It's terribly named. It's called the No Rogue Rulings Act of 2025. Terrible name, but whatever. It essentially creates a 3-panel judge that they would have to vote on to get a national injunction implemented. I think it's stronger than having just one person do it, and it's immediately appealable to the Supreme Court. So go look at it, go learn about it. It might interest you. That aside, I make content for people who are trying to use Uber and Lyft as a stepping stone into something better. I myself, I used to be a district manager. I quit to use Uber and Lyft to become a YouTuber, right? So Uber and Lyft gives you some flexibility. I've used it to pay off debts. I might be debt free this summer, and then I'll be closer to being a full-time YouTuber. So even if you don't want to be a YouTuber, come check out my channel. It's called Future Rideshare Millionaire. I'm not trying to become a millionaire with rideshare, but I'm trying to become a millionaire by using rideshare as a stepping stone to that next thing that eventually gets there. And if that's something you're interested in, come and check me out. Eventually, I want to start a politics channel. I'm just a little too busy. So if you want to come and chat with me, debate with me, follow me on Twitter at Tristan Thomas YT. That's the letter Y and T. So Tristan Thomas YT. It was fun being here.
Yeah, check them out, gang. Give them all a follow, all a sub, and things like that.
I also have a cute dog, by the way.
You do have a cute dog. It's the cutest. We're going to raid out into Prime Kai right now. So make sure you do let him know this is a hate raid. And I will see you guys all tomorrow at 6 p.m. And so bye-bye, everyone.
Thanks for having me. Bye.
Of course. Bye. Bye-bye. Bye-bye. Give it a second. It takes like a few seconds to get there. We're still live, by the way. It takes like 3 seconds. So, it's all good. Thanks.
I got to bounce to a
coming.
Prime panel.
Yeah.
Yep.
Good luck.
I'll catch you later.
Bye.